15 U.S. Code 1607 Administrative Enforcement. Enforcing agencies. Subject to Subtitle B of the Consumer Financial Protection Act, compliance with requirements imposed under this subchapter shall be enforced under Section 8 of the Federal Deposit Insurance Act by the appropriate federal banking agency as defined in Section 3Q of the Federal Deposit Insurance Act with respect to national banks, federal savings associations, and federal branches and federal agencies of foreign banks, member banks of the Federal Reserve System other than national banks, branches and agencies of foreign banks other than federal branches, federal agencies, and insured state branches of foreign banks, commercial lending companies owned or controlled by foreign banks, and organizations operating under Section 25 or 25A of the Federal Reserve Act, and banks and state savings associations insured by the Federal Deposit Insurance Corporation, other than members of the Federal Reserve System, and insured state branches of foreign banks. The Federal Credit Union Act by the Director of the National Credit Union Administration with respect to any federal credit union. Part A of Subtitle 7 of Title 49 by the Secretary of Transportation with respect to any air carrier or foreign air carrier subject to that part. The Packers and Stockyards Act, except as provided in Section 406 of that Act by the Secretary of Agriculture with respect to any activity subject to that Act. The Farm Credit Act of 1971 by the Farm Credit Administration with respect to any Federal Land Bank, Federal Land Bank Association, Federal Intermediate Credit Bank, or Production Credit Association, and Subtitle E of the Consumer Financial Protection Act of 2010 by the Bureau with respect to any person subject to this subchapter. Sections 21B and C of the Securities Exchange Act of 1934 in the case of a broker or dealer other than a depository institution by the Securities Exchange Commission. B. Violations of this subchapter deemed violations of pre-existing statutory requirements, additional agency powers, for the purposes of the exercise by any agency referred to in this subsection, A, of its powers under any act referred to in that subsection, a violation of any requirement imposed under this subchapter shall be deemed to be a violation of a requirement imposed under that act. In addition to its powers under any provision of law specifically referred to in subsection A, each of the agencies referred to in that subsection may exercise for the purpose of enforcing compliance with any requirement imposed under this subchapter any authority conferred on it by law. C. Overall enforcement authority of the Federal Trade Commission. Except to the extent that enforcement of the requirements imposed under this subchapter is specifically committed to some other government agency under any of paragraphs 1 through 5 of subsection A, and subject to subtitle B of the Consumer Financial Protection Act of 2010, the Federal Trade Commission shall be authorized to enforce such requirements for the purpose of the exercise by the Federal Trade Commission of its functions and powers under the Federal Trade Commission Act. A violation of any requirement imposed under this subchapter shall be deemed a violation of a requirement imposed under that act. All of the functions and powers of the FTC under the FTC Act are available to the FTC to enforce compliance by any person with the requirements under the subchapter, irrespective of whether that person is engaged in commerce or meets any other jurisdictional tests under the FTC Act. The authority of the Bureau to issue regulations under this subchapter does not impair the authority of any other agency designated in this section to make rules respecting its own procedures and enforcing compliance with requirements imposed under this subchapter. Adjustment of finance charges, procedures applicable, coverage, criteria, etc. This is E. 1. And carrying out its enforcement activities under this section. Each agency referred to in subsection A or C, in cases where an annual percentage rate or finance charge was inaccurately disclosed, shall notify the creditor of such. We'll go over creditor. Shall notify the creditor of such disclosure error and is authorized in accordance with the provisions of this subsection to require the creditor to make an adjustment to the account of the person to whom credit was extended, to assure that such person will not be required to pay a finance charge in excess of the finance charge actually disclosed or the dollar equivalent of the annual percentage rate actually disclosed, whichever is lower. For the purposes of this subsection, except where such disclosure error resulted from a willful violation which was intended to mislead the person to whom credit was extended, in determining whether a disclosure error has occurred and in calculating any adjustment, each agency shall apply, with respect to the annual percentage rate, a tolerance of 1/4 of 1% more or less than the actual rate, determined without regard to section 1606C of this title, and 2, with respect to the finance charge, a corresponding numerical tolerance as generated by the tolerance provided under this subsection for the annual percentage rate, except that B, with respect to transactions consummated after 2 years following March 31st, 1980, each agency shall apply for transactions that have a scheduled amortization of 10 years or less, with respect to the annual percentage rate, a tolerance not to exceed 1/4 of 1% more or less than the actual rate, determined without regard to section 1606 of this title. I feel like I just read that. But in no event a tolerance, let's find out what a tolerance is. Tolerance is the lenience of a client to tolerate instead of creating a debit or dispute. A lenience of any client to tolerate any short payment or deduction by a customer while making a payment. For transactions that have a scheduled amortization of more than 10 years with respect to the annual percentage rate, only such tolerances are allowed under section 1606C of this title, and for all transactions with respect to the finance charge, a corresponding numerical tolerance as generated by the tolerances provided under this subsection for the annual percentage rate. Each agency shall require an adjustment when it determines that such disclosure error resulted from A, a clear and consistent pattern or practice of violations, B, gross negligence, or C, a willful violation which was intended to mislead the person to whom the credit was extended. Notwithstanding the preceding sentence, except where such disclosure error resulted from a willful violation which was intended to mislead the person to whom the credit was extended, an agency need not require such an adjustment if it determines that such error disclosure resulted from an error involving the disclosure of a fee or charge that would otherwise be excludable in computing the finance charge, including but not limited to violations involving the disclosures described in section 1605B, C, and D of this title, in which event the agency may require such remedial action as it determines to be equitable, except that for transactions consummated after 2 years of March 31st, 1980, such an adjustment shall be ordered for violations of 1605B of this title. An agency need not require such an adjustment if it determines that such disclosure error involved in a disclosed amount was 10% or less of the amount that should have been disclosed. And 1, in cases where the error involved disclosed the finance charge, the actual percentage rate was disclosed incorrectly. And 2, in cases where the error involved a disclosed annual percentage rate, the finance charge was disclosed correctly, in which event the agency may require such adjustment as it determines to be equitable. Agency need not require such an adjustment if it determines that the disclosure error involved a total failure to disclose either the annual percentage rate or the finance charge, in which event the agency may require such adjustment as it determines to be equitable, or resulted from any other unique circumstances involving clearly technical and non-substantive disclosure violations that do not adversely affect information provided to the consumer and that have not misled or otherwise deceived the consumer. In the case of other such disclosure errors, each agency may require such an adjustment. Notwithstanding paragraph 2, no adjustment shall be ordered, not if it would have significantly adverse impact upon the safety or soundness of the creditor, but in any such case, the agency may require a partial adjustment in an amount that does not have such an impact, or require the full adjustment but permit the creditor to make the required adjustment in partial payments over an extended period of time which the agency considers to be reasonable. If in the case of the agency referred to in paragraph 1, 2, or 3 of subsection A, the agency determines that a partial adjustment or making partial payments over an extended period is necessary to avoid causing the creditor to become undercapitalized pursuant to section 38 of the Federal Deposit Insurance Act. The amount of the adjustment will be less than $1, except that if more than 1 year has elapsed since the date of the violation, the agency may require that such amount be paid into the Treasury of the United States, or stop.